Just because you've gone to court and got a judgment that says that you are owed money from someone doesn't necessarily mean that you will get paid. The court doesn't really take any steps to enforce that judgment on your behalf. It is the responsibility of the creditor, meaning the person who is owed money, to enforce that judgment that they've won. There's no guarantee you'll get paid. It really depends on whether that debtor, the person that owes you money, has any assets. That being said, there are various different legal steps that you can take to do what's called enforcing that judgment, meaning trying to get paid. Some of those steps are more time-consuming and costlier than others. Some are fairly easy and fairly straightforward. Some examples of steps that can be taken are that you can register a judgment against any real property owned by the debtor. Real property meaning real estate. You can execute the judgment against the debtor's personal property, which means going through a process to seize and sell any personal assets that they have to recover the amount owed. You can also garnish various sources such as wages or bank accounts. And there are also various court processes where you're able to ask the debtor questions about their assets or their ability to pay, and possibly to kind of set up a payment plan. Generally, it's not something that you have to do right away. You generally have 10 years to enforce a judgment. So while a debtor may not have any assets at the very moment, you do have a 10-year time frame where you can try and recover on that judgment.